Hey there, welcome back. And if this is your first time here, you just landed on the right video at exactly the right moment. Why? Because something happened this month, February 2026, that is going to affect every single gun owner in America, and the headlines you're seeing online are either oversimplified or flat out wrong. Some people are out there celebrating without understanding the limits of what just changed. Others are panicking without realizing what the ruling actually says. By the time this video ends, you're going to know exactly what changed, why it changed, and what you need to do next to stay protected legally. That's the promise. Stick around. Before we go any further, let me ask you something. Are you subscribed right now? Because moments like this are exactly why this content exists. Gun laws in 2026 are moving faster than most people can keep up with. Statistics show that nearly 60% of gun owners get their legal information from unreliable sources, random social media posts, or that one guy at the range who acts like an expert but hasn't read a court filing in his life. We break down the actual court decisions, the real legal language, and what it means for you in plain English. Hit subscribe and turn on notifications so you don't miss what's coming next in this series. It takes 2 seconds, and it could save you from a major legal headache. Now let's talk about how we got here, because without this context, none of what follows makes sense. To understand why this February 2026 ruling is such a seismic event, we have to look back at how the legal landscape shifted over the past few years. About 3 years ago, everything changed with the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. That ruling didn't just tweak how courts analyze gun laws, it fundamentally rewrote the test. Before Bruen, courts asked whether a restriction seemed reasonable or promoted public safety. After Bruen, courts must ask a completely different question. Is this law consistent with the historical tradition of firearm regulation in America at the time of the founding? That shift may sound technical, but it is seismic, because once that historical standard was applied honestly and consistently, a wave of modern gun restrictions suddenly became legally vulnerable. Many states responded to Bruen by trying to ignore it. They passed workaround laws, created expansive new definitions of sensitive places, piled on redundant regulations designed to make lawful gun ownership as difficult and expensive as possible without crossing obvious lines. They figured they could run out the clock on litigation. Well, a coalition of lawsuits filed by regular citizens and gun rights organizations finally reached the circuit court level this month. In a decision that runs hundreds of pages, the court didn't just trim a few problematic statutes. They applied the historical tradition standard methodically and aggressively to 10 different categories of firearm law and found that none of them had adequate historical grounding from the founding era. The result was one of the most sweeping Second Amendment rulings in decades. Let's get into exactly what changed. The first category to fall was magazine capacity restrictions. For years, states like California, New Jersey, and Washington told you that 10 rounds was enough. Anything beyond that was labeled a large capacity magazine and subjected you to criminal liability. The court looked at those limits and asked a simple but devastating question. Is there a historical tradition of limiting how many rounds a firearm can hold? The answer was no. There is no founding-era analog for magazine capacity restrictions because the entire premise of limiting ammunition capacity is a modern invention with no constitutional grounding under the Bruen framework. The ruling also confronted the self-defense reality head-on. If you are in a high-stress defensive situation, your hands are shaking, adrenaline is flooding your system, and you miss several shots. A 10-round limit isn't a policy preference, it's a death sentence. The court ruled that standard capacity magazines, the 15, 17, or 30-round magazines that firearms were designed to use, are arms protected by the Second Amendment. In the states covered by this ruling, those capacity limits are now constitutionally unenforceable. The second category struck down was so-called assault weapon bans. This is where the court got particularly aggressive and analytically precise. States had been banning certain semi-automatic rifles not based on how they functioned, but based on cosmetic and ergonomic features, pistol grips, adjustable stocks, threaded barrels, flash suppressors. The court examined that approach and found it constitutionally irrational. A wooden-stocked Mini-14 and a black AR-style rifle fire the exact same caliber at the exact same rate of fire. Banning one because it looks military while allowing the other is, by definition, arbitrary. More importantly, the court emphasized that firearms in common use for lawful purposes fall squarely within constitutional protection, because tens of millions of Americans own AR-style rifles and similar semi-automatic firearms. Broad, feature-based bans cannot survive under the historical tradition test. No founding-era law prohibited commonly owned firearms based on their appearance. The assault weapon ban framework in the affected states has been struck down. The third category involves extended waiting periods. Several states required that even after a buyer passed an instant background check, they still had to wait 10 or 14 days before taking possession of their firearm. The court asked a pointed and powerful question. Is there a historical tradition of forcing law-abiding citizens to delay firearm acquisition after the government has already approved them? The answer again was no. The ruling also confronted the human reality behind this policy. What about a woman who just obtained a restraining order against a violent ex-partner and needs a firearm tonight for her safety? What about someone whose home was broken into days ago and who now feels vulnerable and exposed? The court ruled that once a person is cleared through federal background check systems, prolonged waiting periods cannot survive constitutional scrutiny. Administrative processing of up to 72 hours was acknowledged as reasonable. Anything beyond that, in the absence of compelling historical precedent, was struck down as a burden on constitutional rights. Now, I need to pause here because this is the point where a lot of people make a dangerous mistake. A lot of people hear news like this and think, great, everything is legal now. That is not how this works. Federal law still applies. Background checks through licensed dealers remain required under federal statutes. Prohibited persons, felons, domestic abusers, those adjudicated as mentally defective, are still prohibited from possessing firearms. Nothing in this decision overrides long-standing federal disqualifications. What this ruling does is reshape how lower courts must analyze state-level restrictions going forward. It puts states on notice that modern policy preferences are no longer enough. Historical grounding is now the constitutional battlefield. Keep that distinction firmly in mind as we continue. The fourth category is gun-free zones, and this one affects your daily life in ways you may not have fully considered. Over the past decade, states dramatically expanded the number of locations where firearms were prohibited. Parks, public transit, restaurants that serve alcohol, large public gatherings, entire town squares. They called these sensitive places and used that label to create legal minefields for law-abiding permit holders. The court examined whether there is a historical tradition in America of broadly prohibiting firearms in common public spaces and found that while certain specific locations, courthouses, legislative assemblies, have long-standing historical support for firearm restrictions, the modern trend of blanketing entire cities with no-carry zones has no founding-era analog. The ruling drew a sharp line. You cannot declare a public park a gun-free zone by hanging a plastic sign on a fence while providing zero armed security or police presence. The court found that if the government disarms you in a specific location, it has a constitutional obligation to provide for your safety in that location. Broad sweeping designations without that security apparatus and without clear historical support are now constitutionally suspect. Enforcement of many expanded public carry bans has been blocked or is facing immediate injunction. Schools and traditional courthouse-style facilities remain protected under long-standing precedent. The fifth category is discretionary carry permit systems, more commonly known as may-issue frameworks. Even after Bruen signaled serious problems with these systems, some local sheriffs and permit officials were still finding ways to deny applications based on subjective judgment. You could pass a background check, complete required training, meet every objective standard, and still be told that you didn't demonstrate a sufficient need to carry a firearm for self-defense. The February ruling makes clear this practice is over. The court reinforced a principle that flows directly from Bruen. Constitutional rights cannot hinge on the personal opinion of a licensing official. Discretionary criteria are a gateway to bias and discrimination. If you meet clearly defined, objective, lawful requirements, the permit must be issued. Shall issue is now the constitutional standard. States operating under restrictive may-issue frameworks are facing intense pressure to bring their systems into compliance immediately. The sixth category involves purchase permit requirements. Some states had layered an additional barrier between citizens and their Second Amendment rights. Not a carry permit, but a permit simply to purchase a handgun in the first place. You had to pay fees, take classes, and wait months just for permission to buy a firearm to keep in your own home. The court made a direct and historically significant comparison to poll taxes, the notorious mechanisms once used to prevent citizens from exercising their right to vote by attaching financial and bureaucratic costs to its exercise. A background check, conducted quickly at the point of sale, was acknowledged as a constitutionally valid safety measure. But a separate government-issued permission slip that costs money, takes months, and requires bureaucratic approval to exercise a fundamental right, the court ruled that unconstitutional under any reasonable application of the historical tradition standard. The seventh category is state-level dealer licensing overlays that go well beyond federal requirements. Federal firearms licensees already operate under strict rules. background checks, record keeping, ATF inspections, and comprehensive compliance obligations. But certain states piled on additional layers: state-specific licensing fees running into tens of thousands of dollars, mandatory video surveillance systems, specialized insurance requirements, zoning restrictions. The court examined whether there is a historical tradition of imposing regulatory burdens specifically designed to suppress access to constitutionally protected goods, and found that while commercial regulation has historical roots, targeted schemes that functionally drive lawful gun dealers out of business raise serious constitutional concerns. In the states covered by this ruling, enforcement of these additional licensing burdens has been halted. That means more competition, better prices, and easier legal access to the firearms market for ordinary consumers. The eighth category involves ammunition purchase restrictions. States like California had imposed background checks for every single ammunition purchase, along with quantity caps and in-state purchase requirements. The court addressed this with a point that is as simple as it is powerful. Firearms are useless without ammunition. If you burden access to ammunition in ways that make lawful self-defense impractical, you are functionally burdening the core constitutional right itself. The ruling found very little founding-era precedent for regulating ammunition access in this manner, and concluded that forcing a citizen through a background check and fee structure every time they buy a box of ammunition constitutes a continuous and unconstitutional burden. State-level ammunition background check systems and purchase caps in the affected states were struck down or enjoined. The ninth category is where the ruling becomes most nuanced and most important to understand precisely: red flag procedures. Red flag laws, also known as extreme risk protection orders, allow courts to temporarily remove firearms from individuals alleged to pose a danger to themselves or others. The ruling did not declare all red flag laws unconstitutional, but it did something almost as powerful. It imposed strict due process requirements that many existing red flag systems fail to meet. The historical tradition analysis revealed that while there are founding-era examples of disarming dangerous individuals, those examples uniformly involved meaningful judicial oversight before or immediately after any deprivation of rights. Modern red flag systems in some states allowed firearms to be seized based on accusations alone, with the accused waiting weeks or months for a hearing. The court ruled that unconstitutional. 3 specific requirements were imposed: prompt hearings within a clearly defined short time frame after any emergency seizure, actual evidentiary standards, not just allegations, and a meaningful opportunity for the accused to appear, present evidence, and challenge the accusation before any long-term order remains in effect. The seize now, talk later era is over. This is a significant recalibration that doesn't eliminate the concept of emergency risk orders, but raises the constitutional bar dramatically. The 10th and final category is mandatory gun registration. Several states had been requiring gun owners to register specific firearms, particularly newly regulated categories, in centralized state databases, sometimes under threat of felony charges for noncompliance. The court examined whether broad registration systems align with the founding-era understanding of the right to keep and bear arms, and found little evidence of comprehensive ownership registries during the early American period. The ruling reasoned that mandatory registration of commonly owned firearms, especially when tied to criminal penalties, raises serious constitutional concerns that cannot be overcome by modern public safety arguments alone. In the affected states, mandatory registration schemes for certain firearm categories were invalidated. The important nuance here is that federal background check records at the point of sale through licensed dealers remain fully intact. What was struck down is state-level ownership registry systems that go beyond point-of-sale documentation. Now let's step back and look at the full picture and give you the reality check this moment demands. 10 categories of firearm-related law. Some struck down outright, others narrowed dramatically, all evaluated under the same constitutional lens, historical tradition. This ruling does not instantly rewrite the laws of all 50 states. It applies directly within the federal circuit where these cases were decided. Other circuits are not automatically bound, though they will absolutely study and consider the reasoning. The legal and political battle is now moving from the big federal court to the state level and into the appellate process. Here is what you must understand before you do anything based on this video. States that oppose this ruling are already filing emergency appeals and seeking stays to keep these laws temporarily in place while they contest the outcome. Some local law enforcement agencies may not yet have updated their policies. Some jurisdictions may attempt to continue enforcing old laws until a specific court order tells them to stop. And creative legislatures are already in the process of drafting new statutes that attempt to accomplish the same goals, using different legal language, hoping the rewritten versions survive the historical test. Do not treat this video as a green light to go out today and make decisions without first verifying the specific legal status in your specific state. Check official state government websites. Monitor guidance from reputable legal organizations that specialize in Second Amendment litigation. The landscape can shift again within weeks if emergency stays are granted. Even as restrictions fall away, gun ownership carries personal responsibility that no court ruling changes. Safe storage, proper training, and strict adherence to all remaining state and federal laws are not optional. Federal prohibitions on possession by felons, domestic abusers, and other prohibited persons remain fully in effect. Using a firearm in the commission of a crime remains illegal everywhere in this country. This ruling reshapes certain regulatory boundaries. It does not create a legal free-for-all. Constitutional rights and personal responsibility have always been two sides of the same coin, and no ruling changes that. What should you actually do right now? First, verify your state's current status through official sources. Do not rely on second-hand summaries, including this video, as your sole guide. Second, stay cautious during transitional periods, because confusion following major rulings is exactly when people accidentally make life-altering mistakes. Third, support the organizations that brought these lawsuits and won. They are the reason this conversation is happening. Fourth, stay educated, because this legal battle is far from over. This ruling is likely the beginning of the next stage in a much larger constitutional evolution, not the end of the fight. Because if history tells us anything, the other side doesn't give up. They adapt, they rewrite, they appeal. And they will continue to push for restrictions through every avenue that remains open to them: taxation, insurance mandates, zoning, liability schemes. The constitutional battlefield is going to be active for years to come, and the decisions that get made in the next 12 to 24 months will shape the legal landscape for a generation. Stay informed, stay responsible, stay ahead of what's coming. And here's the final thing worth saying. Major legal victories in constitutional law don't arrive cleanly wrapped with every question answered. They create new questions, new battlegrounds, and new obligations for everyone involved. The courts, the legislatures, law enforcement, and ordinary citizens who just want to exercise their rights without tripping over legal landmines they didn't know existed. The best thing you can do right now is stay educated, stay connected to reliable legal sources, and make decisions based on verified current information rather than assumptions built on what used to be true or what you hope is now true. The law is a living battlefield. Treat it that way, and you will be in a far stronger position than the vast majority of gun owners who are either celebrating too loudly or worrying too much right now. The truth, as always, is more nuanced than either extreme reaction suggests, and that nuance is precisely what protects you legally and keeps you on the right side of a rapidly shifting line.